Good morning, members. I call to order the Bills Committee, the meeting on the Bills Committee on Statute Law, Miscellaneous Provision Bill 2017. I would like to invite nominations for the post of chairmanship. The nomination has to be made verbally by one member and to be seconded by at least another member verbally and to be accepted by the nominee. So nominations, please. Yes, Charles. Mr. Dennis Kwok. Seconded by Kenneth Leung. I accept. Dennis, I accept. Do I hear any other nominations? There is none. So I'll hand it over to you.
有冇人提名副主席？
Nominations for the post of Deputy Chairman, Mr. Charles Mock, Mr. Kenneth Leung. It has to be seconded. Seconder, Mr. Elvin Young. Mr. Kenneth Leung, do you accept? Yes, thank you, Chair. Any other nominations for the post of Deputy Chairman? No. In this case, I declare that Mr. Elvin Young has been elected as the Deputy Chair. Please invite the appropriate officers to join us.
Jesus. Okay. 得。邊個？我知，即係呢封信啊嘛。呢封信係歡迎。
Welcome, ladies and gentlemen. Will it be Ms. Wen who will walk us through the paper? Thank you, Chairman. We are here to look at the Statute Law Miscellaneous Provision Bill 2017. Maybe first of all, let me talk about the policy. I'll be brief. For this particular bill, there are 9 parts to it. They are sort of proposed by different policy bureaus. We are really talking about largely minor, technical, and non-controversial amendments. I'd like to highlight the major amendments proposed. In fact, they are a response to concerns of the community, in particular the members of the LegCo. We'd like to amend the Criminal Procedure Ordinance as well as the live television link and video recorded evidence rules so as to better protect the witnesses in offences of sexual abuse or cruelty. We'd like to provide a discretion to the court so that the court may, on its own motion or upon application, allow witnesses to give evidence by way of a live television link. Of course, the discretion of the court will include the following. That is, when circumstances permit, certain conditions are to be imposed. And then we have also got some other proposed amendments upon the suggestion by the judicial administrator. Currently, as far as the district courts are concerned, for temporary registrars, they may exercise the same powers and privileges as a deputy registrar. However, the relevant provision when we looked at the High Court Ordinance, the District Court Ordinance, and the Competition Ordinance, we do not have the relevant provision or the corresponding provision in relation to the appointment of deputy registrars. Therefore, the Judiciary Administrator proposes that a relevant provision should be added to such legislation. Another proposal is about the composition of the District Court Rules Committee, and this is about the rules of the District Court hearings. But currently, the composition does not have a representative appointed by the DFSJ, and this differs from the provisions concerning the other rules committees of the, say, for example, the High Court. Therefore, there is this proposal to amend the District Court rules so as to allow for the SJ or his representative to sit on the committee. As to the other proposal to be incorporated into the amendments is in relation to the jurisdictional limit of costs-only provisions. Well, for civil cases, say for example, we have a limit, say for example, $1 billion. Currently, the LegCo, by way of a resolution, may amend the limit. However, the odd man out is a costs-only proceedings. Therefore, every time when there is a need to make a change, we have to rely on the legislative exercise of having a bill. Therefore, we would like to say that we can also rely on a resolution to be passed by the LegCo so as to revise the jurisdictional limit of costs-only proceedings. As to the other proposed amendment, that's in relation to the Legal Practitioners Ordinance. Well, it was a proposal from the Law Society of Hong Kong and agreed by the SJ. Now, currently, if a trainee would like to seek admission, he or she has to meet certain residential requirements, say, for example, for 3 months. Currently, it has been counted from the date of admission. It will be difficult to have certainty because we have to wait for the court to list the application. Now the proposal is to change it to the date of application for a certificate. In other words, the date of application to the Law Society, and we can sort of make it 3 months. There is relative certainty about this date, so we accept such a proposal. And then there is a textual amendment, and that's in relation to the Mainland Judgment's Reciprocal Enforcement Ordinance. In the legislation, there is this reference to 基層人民法院. For the English equivalent, we have been using the term Basic People's Court, but then on the mainland, their translation has been amended to Primary People's Court. So we would like to achieve consistency, and therefore we would like to propose such an amendment. As to the final proposal, that's in relation to the editorial powers under the law's loose leaf publication ordinance. We'd like to give the SJ certain powers so that there will be a greater degree of flexibility. But then this is relatively more technical, so perhaps we can elaborate on this point when we come to that particular piece of legislation. I think members must have received a letter on your table, and it has been issued from the DFJ in response to our legal advisor's queries. So, Ms. Wen, would you like to brief us on the content of the letter? Well, for the first part, this is to give a reply to the question raised by your legal advisor. Would it be better if we talk about those points when we reach the relevant provisions, yes, I think that may be a better arrangement. All right, concerning the policy aspects of the provisions, members, any questions at this stage? Mr. Kenneth Leung. Thank you, Mr. Chairman. If I may invite of the DOJ to talk about the amendments under Part 9. Are they all purely textual amendments without any major changes in our policies? Because we're talking about dozens of them, because I don't actually have much time to read the proposals in Part 9. Yes, Ms. Wen. I'll defer to my colleague, Ms. Wong. Ms. Wong, please. Please switch on her mic. Ms. Wong. Thank you, Chair. Thank you, Mr. Leung, for your question. Your understanding is correct. For Part 9, they are all miscellaneous provisions without any change of policies. Well, from time to time, we have discovered omissions or mistakes in our legislation, so we sort of try to revise them in one go, taking this opportunity. Mr. Leung, there's one in relation to accountants. Would you like to take a look at that? Thank you, Chair, for reminding me. Who else would like to ask questions? Yes, Dr. Helena Wong. Thank you, Chair. Good morning, ladies and gentlemen. If I may ask a question concerning the LegCo brief, and that's about paragraph 4. It is said that under Section 39B of the Criminal Procedure Ordinance, the court may, on its own motion or upon application, permit a person falling within any of the following 3 categories to testify by way of a live television link. In other words, the court may initiate that, or anyone falling into one of the 3 categories may initiate. In other words, a child giving evidence in proceedings in respect of an offense of sexual abuse or cruelty. But then for subparagraph A, under paragraph A, paragraph 3, is it confined to children? If the witness is not a child, then it will be 3C. In other words, does it mean that we are only able to help the children witnesses in cases of sexual abuse or cruelty? If we have a case of sexual abuse, but then the witness is not a child, may an application be made? Ms. Wen? Thank you, Chair. As Ms. Wen has already said, for us to seek an amendment of this nature for certain sexual offenses, that is the specified ones, we are talking about cases like rape, non-consensual, buggery, indecent assault, etc. For such prescribed or specified offenses, witnesses in such cases may apply, and the court may also exercise its discretion and give permission to rely on a live television link. That's why we would like to make such an amendment. In the past, currently, we have only got 3 categories of witnesses, either a child, a mentally incapacitated person, or a witness in fear. So we are going to cover witnesses in specified sexual offenses as well.
So after the amendment, the scope will be beyond A, B, and C. Even adults would be covered, yes. Before the amendment, the court does not have such discretion to allow such persons to give evidence by way of a television link. If the court does not make an application on its own motion, but rather on application by other persons, would the judges have the final judgment, yes, the discretion is vested in the judge, and this is the case at the moment as well. Not all applications would be granted. The judges have the discretion. Can the government or DOJ give us some figures on how often the courts tended to accept such applications? From my personal experience, most of these applications would be granted. From my experience, such applications were seldom turned down. And I believe the judiciary can provide such information. The judiciary, please. Please switch on the microphone for her. The speaker is not coming through. We have no such figures on hand. We might not have the figures requested, and we will try to provide them afterwards. Can you share those figures in the next meeting? Chairman, when the judge exercises such discretion, would there be any rules, or would the judges be bounded? Ms. Wong? When the judge considers such applications, and this falls under the judicial discretion of the judge. So the goal is to ensure a fair trial. The judge would look at the needs of the complainant or witness and whether protection is required. But the judge would also secure the basic rights of the accused, and the objective is to ensure fair justice. So the judge would make a decision based on the circumstances. Both counsels would offer their justifications in support or against the relevant applications. Any further questions from members? I have a question about the support persons. And in the amendment, we want to allow vulnerable witnesses to receive more protection. And in 9.5, support person is mentioned. But in the actual implementation, can we offer more support to such support persons in terms of the vulnerable witnesses? Can we allow the support persons to sit next to the witness and provide support? But at the same time, the support person would be shown on video, so that the evidence-giving process would not be affected. This is somewhat related to this amendment exercise. And some people who have been following the proposals told me that the current system on support persons cannot achieve its objectives. So can the government consider that? Mr. Ho? Thank you. And support persons are mentioned under the live TV link and video recorded evidence rules. As the chairman said, practice directions are granted by the courts, and this has been mentioned under 9.5. And in paragraph 7, for a witness who is a child or mentally incapacitated person, the court would usually approve the provision of support by a support person. And in terms of training to support persons, it's mainly provided by the Social Welfare Department. and psychologists or social workers would render the training. And they can offer appropriate support to the children or mentally incapacitated persons. And in paragraph 8 of the practice direction, for witnesses in fair and support persons are usually not required. For children, mentally incapacitated persons, and adult witnesses, they might have different needs, as we can see. In each case, we would afford different treatment. After the amendment, the presence of support persons might exist for cases involving prescribed sexual offenses, and in the trials, the courts will assess the level of protection needed by witnesses, and the principle of a fair trial would be upheld. So the courts will strike a balance on this. Under the when the practice directions are implemented, social workers, teachers, or relatives are not allowed to become support persons. Would you consider that? As I said, at the end of the day, this is the judgment of the courts, and the court will juggle the different factors, for example, the neutrality of support persons and whether they are trained to offer appropriate support to child or mentally incapacitated witnesses. Any other policy questions from members? If not, let's move on to the clause-by-clause examination. And in some of the amendments, you only amend the Chinese text. So are you going to walk us through the marked-up copy? Let's look at paper 001. Should we go through the Chinese version first? Yes, CB 41376/1617 (02).
咁或者而家係咪去第二步啊？
Shall we proceed to part 2? Yes.
或者我開始需要
And I will start first, and Mr. Ho can supplement when needed. First of all, in part 1, we are amending 79B to introduce the definition of the complainant, and this has to do with section 156 brackets 8, and as for the definition of the prescribed sexual offenses, they include rape, non-consensual burglary, and indecent assault. And what about the definition of witness in fear? For witness in fear, the rendition is more westernized in nature, and the preposition is rendered. So we want to improve the level of Chinese in our text through this legislative exercise. So we will try to avoid such westernized expressions. What is the difference in Chinese between 黃孔的證人 and 黃孔中的證人? And this is a definition. Since it will act as a label or symbol, we will try to go for a briefer rendition to facilitate readers. For the general public, the Chinese 黃孔的 is an adjective, while 黃孔 is a noun. So is that the labeling effects you were referring to? Thank you very much for your view. We will consider it. When we draft definitions, we would usually go for a shorter rendition so that readers would realize that it is a label or marker. If the Chinese is 黃孔的證人, the reader might not realize that it's a specific term or definition. So you are trying to change it into a technical term, yes. In 9.5 of the practice directions of the judiciary, it says persons in fear. So is that equivalent to witnesses in fear? Please switch on the microphone for her. If there are amendments to the wording, we will review it. So does it mean that persons in fear are equivalent to witnesses in fear? Yes, it should be. So if the DOJ makes such switch, the judiciary would also follow suit, yes. If you are to make it a technical term, hopefully all relevant departments would use the same term. There shouldn't be major deviations. Next page. And provisions are introduced to allow the court to make discretion. In other words, subclause 4A in 0002. You did not define what those conditions are, and it only says subject to any conditions the court considers appropriate in the circumstances. So the conditions can be wide-ranging. Correct. In each case, the court might consider a wide range of factors. If we are to give the court such discretion to consider all kinds of factors, it might be related to the request of the complainant or the justifications given by the defense, and we find such wording appropriate. Please continue.
And then we'd like to amend Section 823V, and that's about the powers of the Court of Appeal. If the Court of Appeal has to summon such a witness, we are going to empower the Court of Appeal to do the same. So we are going to add section 13 capital A to section 83V. Yes. For subsection 15, currently we haven't referred to section 13A, and therefore we would like to include the reference to subsection 13A as well. Yes, please continue. And then again, we are changing the Chinese rendition from 在恐懼中的證人 to 惶恐證人. And then what follows are the inclusion of two definitions. There is the definition for complainant and the definition for specified sexual offense. Yes, please continue. Yes. Mr. Holden Chow. Mr. Chairman, just want to make a minor point about the definition for witness in fear. I understand that the definition itself will not be amended. May I take this opportunity to make this following comment? Means a witness in respect of whom the court is satisfied on reasonable grounds is apprehensive as to the safety of himself or any member of his family if he gives evidence. I think that's the existing definition. Bearing in mind the recent sexual offenses that we have come across, maybe the witness isn't just apprehensive of his own safety, but then he may also have some psychological fear. So I want to know whether this will be covered as well. I don't think I can actually suggest any amendments off the cuff, but then here you talk about as to the safety of himself or any member of his family, and he is apprehensive of that. I don't know whether we should expand the coverage in addition to what is defined here. So witness in fear. Witness in fear, we have got a definition. The scope is quite narrow. As Holden Chow has said, it is just about being apprehensive as to the safety of himself or any member of his family. So we may not be able to cover the complainants of specified sexual offenses, and therefore we would like to add a provision that is 4A, 13A, just to provide protection to complainants in specified sexual offenses. All right, please continue. Yes, Mr. Kenneth Leung, if I may ask a broader question. Other than the video link approach to give evidence, I want to know whether there are other ways to protect the witnesses when they attend the court. Of course, the video link is one of the measures. I want to know if the court has discretion to protect the witnesses in other ways as well. The judiciary. Thank you, Chair. Thank you, Member, for this question. We have been giving an account to members of the AJLS panel as well. Other than the live television link, we have also got the protective screen. We are not able to make an amendment. We have not been able to make an amendment, but then currently what we have been doing is that for someone who is emotionally unstable, the witness may want to see the defendant, and then we may put in an application, and then the court may grant the permission so that there is a screen so that the witness cannot see the defendant. But then it is to be an application made case by case, and we have got the practice directions to cover such scenarios. The witness has to make an application, and it is and the defendant or the defense counsel may also make an objection. I mean, we have to consider issues like open justice. Now, if there is a video link for the witness to give evidence, I want to know whether the witness can be seen by whoever is present in the court. like the jurors as well as the members of the public. Is it possible for the witness to say that she doesn't want her face to be seen by others? Thank you for the question. Well, yes, indeed, this can be done. Upon an application, the court will give consideration. There are certain ways to make arrangements so that only the witness can only be seen by either the judge or the defendant or the defense counsel. In newer court buildings, we have got huge television screens, and when the court permits, then the screen or the monitor will be switched off. Then ordinary members of the public will not be able to see it. And sometimes we can also use a screen to hide the television screens or the monitors, because members of the public in the gallery may be able to steal a look of the screen of the defense counsel. We can also use the kind of screens used in banks, so that it would not be easy for others to see it unless you are within a particular range of angles. In this way, we are able to achieve the purpose of protection. Dr. Fernando Zhang, thank you, Chair. We paid a visit to the judiciary. We saw for ourselves the relevant facilities. The judiciary also explained the relevant arrangements to us. For the live television link for giving evidence, we were not able to have a live site visit, but then we were told that for witnesses in fear and for vulnerable witnesses, we haven't got the arrangement to allow a support person to accompany such witnesses. So for a vulnerable witness, I think it is important to be given support. We raised the point, and we were told that when a witness gives evidence, and if a relative is next to him or her, the facial expression or may erode the integrity of the evidence. We considered the matter. We said that as long as the witness knows that his support person is present in the same room, say for example the support person is behind the witness, and of course the camera will be facing the witness. In this way, the witness will not be able to see her relative, though she knows the presence of the support person. Then in this way, we can still have the live television link without jeopardizing the integrity of the evidence. Of course, I don't expect the provision to go down to such details, but we believe that such an arrangement can assist the witness. So I want to know if this has been given consideration and whether there's room for further consideration. Well, Mr. Ho has given detailed explanations before Dr. Zhang's arrival today. During your visit to the judiciary, a similar point has been raised. Well, from the perspective of the judiciary, we need to bear in mind justice, and the court will also take into account the need to be neutral. We have to strike a balance between the needs of the two parties. On the one hand, we have witness in fear. We have also got complainants in sexual offenses. We have to be attentive to their needs, their emotions, as well as their requests. At the same time, it is also important to make sure that the defendants have their rights exercised. And in particular, we have to make sure that the defense counsel will be able to examine or cross-examine the relevant witnesses. Therefore, we believe that making it unbiased is important. Any arrangement that may give rise to the possibility of others giving hints or jeopardizing the impartiality of the evidence will be causing us worry. Say, for example, let me cite an example. Sometimes we may need an interpreter to assist the witness. Say, for example, we may have a language which is uncommon, and then during the stage of police investigation, an interpreter might have already been enlisted for help. When the judge understands that the same interpreter has been involved in the police investigation, even though we are merely talking about the interpreter, but since that interpreter has already played a role at an early stage of police investigation, the same interpreter cannot be used during the court hearing. But of course, if it is a uncommon language and we've only got, say, for example, 2 such interpreters for the same language in Hong Kong, we may have to think otherwise. Otherwise, for the sake of justice, this arrangement would not be acceptable. And then earlier on, this point has been raised. That is, for some complainants, they may be emotionally unstable. Say, for example, when it is a case of sexual assault, the witness may cry or the witness may be upset. This is understandable. And the Court of Appeal has also included this suggestion in the practice directions. Well, the judge can see for itself that the witness becomes emotionally unstable. Of course, the court will take into account many factors. Sometimes the hearing may be suspended briefly. And for Dr. Jones' point about having a relative nearby, I'm not sure whether Dr. Zhang has been taken to that particular room. We're talking about a small room within the larger courtroom. Well, currently, we try to allow the support person to be present in the smaller room, but then it will be someone not known to the witness. But then, say, the mother may be seated outside the witness room. If the witness, say, for example, the complainant is emotionally disturbed and the court thinks that it is not right to continue, then the the hearing will be suspended. The witness will come out and then she can be sort of assisted and become composed again. So we believe that it is important to uphold the impartiality of the hearing. We will try our best to make sure that the witness will calm down first before continuing with the giving of evidence. Mr. Chairman, for an vulnerable witness, if she has a family member present, she'll have view of the family member if she's giving evidence in ordinary courtroom. On the other hand, when she's using the television link, she'll be alone, although she may know that her family member is right outside her witness room. So logically speaking, in terms of logic, it is rather odd. It is said that we mustn't affect the impartiality of the case. If you say that her view of a family member would jeopardize the impartiality, but I have to point out that she can already have view of a family member in a large courtroom. What about if she can see her family member, while we make sure that the family member will not affect her evidence? I think we need to consider this point to make sure that the hearing is fair. Of course, I can appreciate Dr. Fernando Zhang's point. Say, for example, witness is giving evidence and I am the witness. I can see my family member who is present in the public gallery. But when I'm in the witness room, then I'm alone and then my emotions may be disturbed and then this will affect my evidence.
Would
the judiciary consider that? Thank you. As we said, ensuring a fair trial and neutrality are essential in court proceedings. We know that some vulnerable witnesses might prefer the company of their family, and with the court's approval, we might suspend the taking of evidence. when you look at the actual operation of our live TV link, the judge might not be able to see whether another person familiar with the witness is present in the room, and we might not be able to see very subtle cues given by them. But in a fair trial, the judge can see everyone. If anyone wants to give a cue or influence the witness, then the judge and the counsels can also see them, and this is more in line with our principle of having a fair trial. Ms. Olin Chow and Ms. Elvin Young. Mr. Chow, please. In the government's response, they said that the witnesses in fear refer to a narrower group of people, and I understand that. And I have a question similar to Dr. Fernando Chang's. In some cases, for a case involving sexual offense, there might be an appellant and also a witness. And a witness might be giving evidence. And he or she might not be defined as a witness in fear. In other words, his or her being is not being threatened by giving evidence, even if that person, well, the act of giving evidence, even by way of a live TV link, might trigger negative emotions or responses. For witnesses who are not classified as witnesses in fear and that they are not complainants, what kind of protection can be given to them? Well, Ms. Wong mentioned other forms of protection for these persons, but for the example I cited, for this specific type of witness, can they be protected under the ordinance? Mr. Ho, as we said, the specified sexual offenses only cover some sexual offenses, but not all. If a person witnessed the sexual offense and he or she might be frightened, then the proceedings of this amendment exercise would not apply. Just now, the judiciary said other equipment are available, for example, screens. If that person is still embarrassed and he or she does not wish to see the accused, and an application can be made to the court. For more serious sexual offenses, in reality, persons who are not complainants are seldom subject to trauma, but if that's the case, we can still deal with it. For persons who witness sexual offenses, but then they are not complainants themselves, sometimes this would happen on children. And for children, the live television link proposal would apply. Ms. Elvin Young, Chairman, I want to follow up on Dr. Fernando Chang's concern. I understand the judiciary's principles. For any trial, fairness is essential. I'm sure everyone would agree. But Dr. Chang's concern is on the care for witnesses in fear and how we can alleviate their fears. Just now, the judiciary mentions a room inside another room where the live TV link would take place. And in that small room, the witness in fear cannot see other persons, and in the same space, a representative from the judiciary would be present, and that representative is completely unrelated to this witness. Such witness in fear must be anxious because he or she is accompanied by a stranger. Can we install single glazed glass in the room similar to the arrangement in police stations, and the family member can sit outside, but the person outside cannot see who is inside, and you can avoid the you can prevent the family members from giving cues. Then you can alleviate Dr. Chang's worry while still maintaining fairness. I wonder whether this is possible for the judiciary, and in that small room, if a family member of this witness in fear is present, and if the judge can see that person as well, who is seated behind the witness, this is like a TV anchor, and the accompanying person is seated next to the witness, and the witness in fear knows that his or her family member is seated behind him or her. And a third person would also be present to make sure that there would be no issues. So these are my two recommendations. I wonder if the judiciary can consider them. As we said, neutrality is most important. And it might not be appropriate for family members to influence witnesses in any way. As for the suggestion of the one-way mirror, we can discuss with our judges afterwards. As we understand, we know that members are thinking from the perspective of victims, so extensive consultation would be required to know about the views of the legal professional bodies. In your letter, you mentioned clause 3(4). Can you explain that to us now, since we are at it already? So this is a drafting issue. So from the drafting division, please. Thank you. The speaker is not coming through. First of all, I'd like to address the legal advisor's question. The question was about Section 79B(4) and the new provision. The expression is somewhat different from the existing wording, and in 4A, it says impose suitable conditions as deemed by the court to restrict the leave, and this is different from the original expression in 79B(4). Section 79B(4)(a) is a new section, and we have adopted the use of plain language in recent years. So in new provisions, we want to make them as easy to understand as possible for the reader. And I want to stress that the legal effect is the same. And in our new legislation, we want to make the language as plain as possible. So this has been our practice in recent years. The legal advisor also mentioned the comma in the phrase, and they asked about the reason for using the comma. The drafting division conducted some research on the use of punctuation in the book. Words, sentences, and punctuations, and the writer said that the comma is to indicate a general pause within a sentence used where a change of breath is needed in speech. And since there is a serial verb sentence and a comma is added to indicate a change of breath, and the use of a comma can split up the sentences and facilitate plain language and easy understanding. Dr. Fernando Chang. Apart from victims of sexual offenses, sometimes children or mentally handicapped need to have family members in a company. Providing a CCTV link is a form of protection, but at the same time, you are taking away another form of protection. Our concern is whether the judge or other officers who would help ensure a fair fitness would have to see whether there's any acts of injustice in the venue. I think it's a technical issue rather than a question of principle. If this is a technical matter, I hope the judiciary would work hard to get around them. Since we are looking at fair, open trials, we have various parties present. Of course, family members might conduct acts that are that would prejudice fairness, but those they would also be monitored, and if they conduct such acts, they can be stopped by the courts. So I think I hope that technically this can be built into the current arrangement to offer protection to the witness. And this is for autistic or mentally handicapped children. It's important to have their family members present. I've seen a lot of children when they are in fear, for example, when they are in hospital. If their family members are present, everything would be much smoother. So I hope the judiciary can seriously consider that. Thank you. I will relay your comments and we will have discussions. You have a very nice court building at West Kowloon. Can the facilities achieve what Dr. Chung suggested while ensuring a fair trial? You can ensure witnesses in fear or vulnerable witnesses to give evidence with peace of mind. Thank you. We will first consider the matter of principles, as I said, and after that we will see how we proceed. Mr. Kenneth Leung, I'd like to follow up on what Dr. Fernando Chung and Mr. Alvin Young said. When we look at neutrality or cost considerations, if a family member is seated behind the witness in fear, there could be another screen set up at the judge's seat to show the accompanying person. I think that can solve the problem, and there is no need to install single-way cameras or make any structural changes. If you have a CCTV on the accompanying family member, and the image can only be accessed by the judge, and this is something you can consider. Thank you.
Anything to add? No, Mr. Chairman. Please continue with the clause-by-clause scrutiny. I think we should resume at page 0006, and that's in relation to the amendment to the subsidiary legislation, namely live television link and video recorded evidence rules. Since we have also got subsection 4A, so we are going to refer to 79B, section 79B, instead of what we have got currently. And then part 3, page 0007 of the Chinese version. We'll talk about the High Court ordinance, the competition ordinance, etc. So we are actually referring to the case of temporary registrars at different levels. We hope that their powers at different levels of the court will be clarified. There is a genuine need to have temporary registrars for a brief period of time. So temporary registrars will need to have the same powers and same duties as the deputy registrars. So we've made reference to the relevant ordinance. So we're trying to achieve consistency. We are going to add 2A to section 37AB, so that a temporary registrar will have all the powers and duties of the registrar. Questions, please, members. If I may ask a question. Well, the drafting is the same.
During the period for which he or she is appointed. 呢啲咁累贅嘅 drafting, he or she 呢，你哋有冇喺個 general clause and interpretation ordinance?
Have you done anything so as to make sure that you don't need to talk about he or she? I want to know whether such a drafting is still present in our legislation, so that you always have to mention he or she all the time. Can anybody answer my question? DFJ, please. Ms. Wong. Thank you, Chair, for your question. We have to say he or she because we want to be gender neutral. When you look at the structure of the sentence, the only thing we can do is to say he or she. It may be a bit lengthy, but then it makes it clear that we are being gender neutral. I want to know whether we've got the same in our law books. That is, whenever we talk about the position or the rank of an officer, you will always use he or she. For Cap 1, if you make it clear that whenever you use the word he, it implies she as well, and then him would also include her as well, then you don't have to have this drafting every time. So I just wonder if you would like to pick up my idea so that you can sort of make it simple. Yes, I understand it is important to be gender neutral. However, my question is, are you going to make changes to the General Clauses Ordinance, Interpretation and General Clauses Ordinance? Mr. Ng may want to add to my answer. Mr. Chairman, I think you are right in your point. That is for Cap 1, that is Interpretation and General Clauses Ordinance. In particular, Section 7, we do say that when we use words implying that we're talking about male person like he, then she is being implied as well. But then in recent years, our drafting approach gives more weight to gender neutrality. So we'll rather have gender neutral words. Despite the provision in Cap 1, our latest practice is to avoid using he only. Mr. Chairman, you have also asked if we can sort of share with you the practice in overseas jurisdictions. Well, in fact, it is a trend in overseas jurisdictions to give weight to gender neutrality. So this is a policy change to emphasize ever more that we are talking about he or she. All right, other colleagues, sorry, the speaker is not coming through. Well, there are 4 ranks. We have got the registrar, and then we have the deputy registrar, assistant registrar, etc., and also a senior deputy registrar. So, in fact, the proposed amendments are the same. Any questions? No? Then we can move on to 0012, District Court Ordinance. The proposal is similar, but then this is related to the district courts. So under 14AB, we're talking about the temporary registrar. All right, thank you. We can move on. 0013, Competition Ordinance. Well, as a result of changes to the High Court Ordinance and the District Court Ordinance, we believe that it is a good idea. We believe that we should standardize the references to achieve the same purpose. All right, thank you. Do we have the provision for deputy registrars in other public organizations or statutory bodies like the SSO? What about the misconduct tribunal? Perhaps there is a need to appoint a judge. Of course, I'm talking about full-time judge. I'm not sure whether under other legislation we have a judge or a part-time judge or a registrar to be appointed. So what about tribunals in other statutory bodies? Do we have provisions concerning the appointment of registrars? Have to carry out an exercise to examine whether there is a need for such? For temporary registrar, we aren't talking about a part-time judge. In fact, it is still a case of being full-time, but then it's for a short period of time. Well, a temporary registrar has, during the period for which he or she is appointed, all the jurisdiction, privileges, powers, and duties of the registrar. And this is important. And a reference in any law to the registrar is to be construed accordingly. In other words, we don't need to cover all the 600 pieces of legislation. We don't have to comb through them one by one. Whenever we talk about the duties of the registrar, and as a result of this amendment, all temporary registrars will automatically be given all the powers and duties of the registrar, as well as privileges found in other legislation. So there's no need for us to go through the law book thoroughly, as suggested by the chair. All right, thank you. Any other questions? No? Then please continue. Part 4. I will continue. English version 0014. Under the District Court Ordinance, we have the composition of District Court Rules Committee. This is to assist us with the procedures of district courts. We have noted that we have got quite a number of such rules committees, like High Court Rules Committee. We have noted that for the District Court Rules Committee, we haven't got a representative of the Secretary for Justice. Well, the Secretary for Justice has all the time been giving us helpful advice. Therefore, we suggest that under 1A, we should make a change. We are simply listing out the various members. We are now adding subparagraph F, so that there will be the Secretary for Justice or legal officer appointed by the Secretary for Justice. I understand that you are going to have 4 members being the quorum, right? Half of the members, right? Yes, currently the quorum is 3. Since we are going to have an additional member by having the S4J or his representative, therefore correspondingly we would like to make the quorum stand at 4. What about the chairman? Who will be the chair? Who will be the chair among the members listed in subparagraphs A to F, or who will be appointed? It will be the Chief Justice of the High Court. Next, Part 5, for somebody to be admitted as a solicitor, he should meet certain requirements concerning residence. Before we move on, I think our legal advisor would like to say something. Please switch on the mic. I will ask the relevant law draftsman to pick up this point. That's about the differences in the drafting concerning the Rules Committee in the Court of Final Appeal, as well as what we are proposing. Thank you, legal advisor. As accounted for in our paper, now we are talking about the SJ or his representative in the District Court Rules Committee. We aren't having exactly the same kind of committee as that for the CFA. Must it be a legal officer working in the DOJ, or can it be somebody from other departments? That's the difference. I understand that there are different ways of drafting in the existing legislation. For the District Court Rules Committee, I think its operation is more in line with that of the High Court Rules Committee, and therefore we are having a similar arrangement as that within the High Court Rules Committee. In other words, the SJ will have more flexibility to consider legal officers working in the DOJ or legal officers temporarily posted out to other departments. Mr. Holden Zhao. Thank you, Chair. Well, understand that you have 1B to be added. The registrar is to be the Secretary of the Rules Committee. I want to know who is the current Secretary of the Rules Committee. That is before the amendment, right? Before the amendment. Thank you for the question. We're simply spelling out the current practice in the law. For the High Court Rules Committee as well as the CFA Rules Committee, we spot that there is a difference. But you don't need to worry. We are always having the registrar as the secretary. Any other questions? No? Then Part 5. Residency requirements for admission as solicitor in Hong Kong. We have already explained that is the Law Society has made a proposal, and that is to make a change in relation to the residency requirement. It should be the date of application. Therefore, first of all, for Section 4, subparagraph 1A, and we say that it should be the date on which the person applied for the certificate. Is it initiated by the Law Society? Yes. Junius Ho, any question? No? Then please continue.
From starting from page 0015, we are looking at the admission and registration rules and the relevant forms. and these forms might be application forms to the law society or certificates issued by the society. And at the relevant spots, we change the dates from the dates of admission to date of application. If we have no further questions, we can proceed to part 6. And for part 6, we are looking at page 0025. Mainland Judgments Reciprocal Enforcement Ordinance. First of all, for the long title, we want to introduce the word agreement. It might have been omitted by mistake in the past. Please continue. For page 0026, and in the definitions or the interpretation, the English rendition has been changed from basic people's courts to primary people's courts. For the long title in part 6, there are no changes to the English, right? Yes, the English version is correct. Please continue. Legal advisor. The date of enforcement would be different. The date of commencement is different. At the primary people's courts, there are lists, and these primary people's courts refer to different provinces and districts, etc. And we will publish the updated lists on Gazette again in order to facilitate our work. That's why a date has been prescribed so that our colleagues would know when the updated list would be published on Gazette again. You talk about recognized primary people's courts, so are there unrecognized primary people's courts? So what is the purpose of the word recognized? So by whom they are recognized? Would they be recognized by both jurisdictions or else? This refers to the relevant agreement, and as I understand, a list has been gazetted listing the procedures and judgments of the primary people's courts before they are enforced by the Hong Kong courts. Any questions from members? Please continue. Part 7 from the drafting division, please. Ms. Wong. Part 7 are technical amendments relating to laws compilation, and this includes legislation, publication, Ordinance Cap 614, and the Laws Loose Leaf Publication Ordinance 1990. And our legislation our laws were compiled based on these two ordinances, but we identified some inadequacies. So through this amendment exercise, we want to rectify those areas. And on page 0027, on the interpretation on consolidated copy, and we want to add the phrase, if any, after the phrase means a copy of the ordinance in order to clarify the meaning. And on page 0028, and in clause 4, contents of database, or section 4, and in paragraph Subparagraph A. Consolidated copies of ordinances that have been given chapter numbers under Section 11A. But we realize that chapter numbers are not always given. For example, Cap 614 is the chapter number, but in some ordinances, no chapter numbers are given. For certain time-limited ordinances, chapter numbers might not be given. And on the right side of 0028, 5 ordinances are mentioned, and we did not give chapter numbers for all of these, including the revised edition of the Laws Ordinance 1965, Laws, Loose Leaf Publication Ordinance 1990, the Hong Kong Reunification Ordinance, the National Flag and National Emblem Ordinance, and the Regional Flag and Regional Emblem Ordinance. No chapter numbers are given for these ordinances, so we feel that they should be added. So if they are not given chapter numbers, where do they lie within the laws of Hong Kong? This is just a general question. And the legislation publication ordinance, the information would be stored in a computer database, and it can be searched or indexed quickly. All the unnumbered chapters would be located in Volume 1 or the constitutional documents. No chapter numbers were given because we knew that they could be located in the constitutional papers. Any questions, Dr. Junior So? Speaker's not coming through. Please speak to the microphone. Ms. Wong said the arrangement facilitates indexing. If we are to give a chapter number to the Hong Kong Reunification Ordinance, would it be technically difficult? For the Reunification Ordinance, National Flag and Emblem Ordinance, the Regional Flag and Regional Emblem Ordinance, can we give chapter numbers? There are a few points to consider. The powers to give chapter numbers are present, but due to their unique nature, right now chapter numbers are given in order. Now we are at 600 odd. If we are to give a chapter number, we have to follow the order. For the Hong Kong Reunification Ordinance, it might be at chapter 600 something, and it might not reflect the unique nature of the ordinance. Right now, they are bundled in the constitutional papers rather than designating a specific chapter. But of course, the power to designate chapter numbers is there. Dr. Ho, I understand their constitutional status. If the chapter number is 600 something, their unique nature cannot be reflected. Since this is a constitutional paper, what can we really do? Can we assign a special number? Cap 1 is the Interpretation and General Causes Ordinance. So can we assign a number to reflect the same importance at Cap 1? Can we have 1, 1, 1A, etc.? Thank you. We can consider that, but we do have to balance different views. For chapter numbers, we don't have 1A, 1B. We only use numerals. If we have 1A and 1B, they would fall under subsidiary legislation because this would affect other pieces of subsidiary legislation. For the main legislation, they would use numerals, but for subsidiary legislation, we would have 1A, 1B, 1C, etc. So if we assign 1A to the Hong Kong Reunification Ordinance, the arrangement for other pieces of subsidiary legislation would be affected. But if we use the Roman numeral 1, then we might see other problems. So we have to balance different factors. Dr. Ho? Right now, do you still have loose-leaf publications which are blue? We have a transitional period. For laws with verified copy, there would be no relevant loose-leaf publication. And in the loose-leaf version, and we will include a sentence saying that it will not be published again since it's already on the computer system. But it takes time from verification to transfer to the computer system. In the meantime, there would still be loose-leaf publications, but if a law has been verified, it would no longer show up as a publication. So for all amendment bills and the relevant amendments, if they are unverified, they would still show up on the loose-leaf publications. So what is the verification procedure right now? We have to be very careful in the verification, and ordinances in the database would have a statutory function, so we have to be very careful and meticulous in our verification. We consulted the Law Society, Bar Association, the Judiciary, and LegCo. We will verify the more commonly used ordinances first. We come up with a list after consulting these bodies. So for the more common ordinances or laws, they would be verified first. For ordinances involving major amendments, those might be verified sooner as well, but it depends on our manpower and establishment situation. But our goal is to verify as many laws as possible soon, but it does take time. When the user reads the loose-leaf edition, well, we have a full set at the LegCo library. Unless you have a note saying that you have to refer to the verified version. So all loose-leaf publications would still be up to date. Is that the correct interpretation? I think it depends on what you mean by updated. A loose-leaf publication is a print copy, so there is a time lag, and for the latest loose-leaf edition, but would it be up to date as of today? This is something I cannot say for sure. Please continue. On page 29, it's a technical amendment on section 11 on the powers to give chapter numbers, etc. The powers would be vested in section 12, so this is merely a technical suggestion, and section 12 is on 0030. And under section 12, there would be a new paragraph AA. The Secretary for Justice can make editorial amendments, and according to paragraph AA, if a chapter number has been given to the ordinance under section 11A, the title, short title, or citation of the ordinance can be altered. So, in other words, assigning a chapter number. If we are talking about the company's ordinance, we will add the chapter number 622 for the ordinance, and the amendment on paragraph AA is a consequential amendment. Please continue. In paragraph AB, it's a technical amendment. if an ordinance is cited in another ordinance, the chapter numbers can be given to the other ordinance under the legislation publication ordinance.
Or if we have the Gazette notice number again, we can give the number. This is a technical amendment. We need this amendment. This is because sometimes we may not be able to give a chapter number. It is not appropriate to do so. Say, for example, we have an amendment ordinance, and we may be referring to another ordinance. The amendment ordinance itself will not get a chapter number. It will at most be given a Gazette notice number, so we need to provide for that. 0035, we are redrafting section 14. It is technical in nature. This is because we just want to align the drafting with that in the loose leaf ordinance, and later on we will show you the changes to the loose leaf ordinance. Sections 15 and 16 will be amended. They are consequential amendments after we have amended section 14. And then 0036, starting from that, and that's in relation to Division 2, and I've just referred to the need to change two other pieces of legislation, loose leaf publication, as well as one other piece of legislation. Chair, as you have said, we're in the period of transition. On the one hand, we have the loose leaf publication. On the other hand, we're updating the database. So the relevant powers will still be needed for the loose leaf publication. So for pages 32 and 33 in the Chinese version, we are sort of making the corresponding changes, but of course they are for the loose leaf publications ordinance. Questions, please, members? No? Thank you. Then I think we move on to another part, right? Part 8. For Part 8, that's about the District Court Ordinance. Please go to section 73A. In that particular section, we talk about the amendments of limits of jurisdiction and other amounts. We have referred to a number of sections. And in fact, 53A5 has also got a limit of the jurisdiction, but it has not been included in 73A. Therefore, we are proposing a technical amendment so that 53A paragraph 5 will also be included under 73A, so that the relevant limits of jurisdiction may also be amended by resolution of the Legislative Council. Thank you. Can you explain to us about the background of the costs-only proceedings? Indeed, in year 2008, as a result of the civil justice reform, there was this change. That's in the year 2008. What it means is that if all parties have already arrived at an agreement on everything else other than the costs, then the parties may go to the court and ask for a judgment. So it is a simple procedure. So if they only have different opinions concerning the costs, then they may go to the court and they may ask for a judgment. Thank you. All right, that's it for Part 8, and that takes us to Part 9. Which public officer will walk us through? Yes, thank you, Ms. Wong. Thank you, Chair. We have already told you when the meeting started that we are actually talking about a number of miscellaneous amendments so as to fill the gaps and repealing certain provisions which have already lost effect, or we are deleting outdated references. So starting from page 0040 in the English edition, there are all such amendments. First of all, would like to repeal the notice under Cap 1 Subsidiary Legislation B. This is because in 1993, when the law was amended, it has already been repealed. The notice has already lost effect a long time ago. But then to tidy up our law book, we would like to formally repeal the notice, despite the notice having lost its effect a long time ago. And then the following page, and that's about a very technical amendment. And that's about 34B. It is just a typo in the Chinese version about the court hearing. And then the bankruptcy ordinance, again rectifying the typo, and that's for 51A. There is no need for the Chinese character yi. Page 39 of the Chinese edition. Well, in relation to the Chinese rendition, for the title of the court, instead of Supreme Court, it should be High Court. The name of the court has been changed since 1997. The following page, again a typo. That is for schedule, Form 27. We should have included the Chinese character dai in front of the reference to the relevant section. And then section 14, 1C of the Land Tribunal's Ordinance, we should have added the word cup, that is N, so as to show the relationship. Please continue. Page 42, Chinese version. Same point, and that's about the definition for disqualification. We haven't got the linking word. There should have been the word or in Chinese to link up A, B, C, and D. And then page 43, again a typo. That's about the insurance company's ordinance. Instead of or, it should be and. So the same is true for the English version, right? Yes. And then for section 44, page 44, again the same is true. I think you can see it very clearly from the English version as well. It should be 123 or 124 instead of and. And then the Professional Accountants Ordinance, again it is a typo. For 33B, bracket 3B, towards the end of the paragraph, it talks about dissolving the committee. It should be a sentence so that it talks about dissolving the committee. It should not have come under paragraph B. It should be governing both A and B. So we are removing the location of that particular phrase so that it will govern both subparagraphs A and B. Over the page, again a typo. It's only related to the Chinese version. 的裝被曹 should have been superfluous. And then Chinese version only, and there's in relation to the surviving spouse and children ordinance. And then page 48, We are going to rationalize it because the relationship is not clear. Well, in fact, the corporation should meet all the relevant descriptions. So we are clarifying the conditions that the corporation needs to meet. And then what follows are two minor textual amendments. Page 49, Chinese edition. And we need to make an amendment because Schedule 3 to the Telecommunications Ordinance has been repealed, but we haven't done so for the Chinese version, and we need to clarify this one and update it. Page 50, again, it is a textual amendment. This is because it talks about 維持該條例, etc. Well, that is to qualify the vehicles on the road. So for the Chinese version, it isn't very sort of smooth, and so we would like to fine-tune the language there. No change in the substance. Page 51, similar revision. Page 52, no change because you need to read page 53. Something has been taken out, and that's in relation to Section 23 of the Inland Revenue Ordinance, and we refer to Section 52(3) of the Insurance Companies Ordinance, and that has been deleted, so we have to make a corresponding change. Pages 54 and 55, we are rewriting Schedule 13 to the Public Health and Municipal Services Ordinance. We are numbering the various civic centers so as to make it easier to read and easier to refer to them. Page 56, again, we are sort of rectifying the scientific name of the item involved. Pages 57 and 58, and again we are giving a serial number to the various museums, similar to what we have done a moment ago. And then 59, a Chinese typo. 容器或裝載, you should read 容器及, that is end. So we are making a change to the Chinese edition. Similarly, for page 60, 除害劑或 instead of 除害劑及. Page 61, if you care to turn to the English version, that's about the registered premises. So the word 註冊 has been missed out in the Chinese version. Page 62, you need to read on, and that is page 63. So we are going to make a change to both section 12 and section 13. For section 15, it has been repealed, and therefore in sections 12 and 13, whenever we refer to section 15, that should be deleted. Page 64. So we are sort of fine-tuning the format, the layout, instead of any change in the substance. Similarly for 65. And then for 66, subsection 3 has been deleted. So we need to make a corresponding change to subsection 1 and 2. Page 67. Similarly, subsection 3 has been repealed, so we have to remove the reference from subsection 1. Starting from 68, that's about the rate of amendment. It should now read the amount of payment. Instead of referring to the rate, we are actually referring to the amount. So whenever it talks about the payment rate, it should now read payment amount. And that is true for pages 69, 70, 71, 72, 73, 74, 75, 76, 77, 78, 79, and page 80. All right. So that takes us to page 81. Well, I think originally it says that emitted or leaked from vessels.
The
original meaning referred to the oil entering Hong Kong waters, even though the vessels might not enter Hong Kong. In the Chinese version, does it mean that the oils were leaked outside of Hong Kong waters and vessels would be held liable? Is that what you meant? The vessels might not be discharging those oils within Hong Kong waters. It might be done within or outside of Hong Kong waters, so long as the oils enter Hong Kong waters. There are a lot of vessels outside the waters of Hong Kong. What about the English version? Can you show me the English version? There's no English version, right? Do you have the original version of English? We are trying to locate it. We are only amending the Chinese version. So in the marked up copy, we have not included the English. Let me read it out.
From which any oil is discharged or escapes into the waters of Hong Kong.
The waters. 周浩鼎議員。
多謝主席。
Mr. Oden Chow, I agree with the chairman. I think the actual execution would be difficult if a vessel discharges oils in Hong Kong waters, and you can find out. But what about vessels outside of Hong Kong who discharge oils into Hong Kong waters? What can you do? For this amendment, it's not a minor amendment at all. Before you suggest this amendment, have you consulted the vessels trades? I think this is a substantial change to enforcement. Ms. Wong. Thank you. We have not changed our policy objective through this amendment. We are only making amendment that could not be reflected properly in the existing version. The English version is very clear, as you can see. In terms of enforcement, we can relay your views to the Marine Department. Before we make this proposal, we consulted the relevant Policy Bureau and Marine Department on their policy objective. And they feel that the English version more properly reflects their intention. That's why we are amending the Chinese version. But in our point of view, we have not changed any policy intention, but we can reflect your views to the Marine Department. Thank you. So for the trade, well, the English version has always remained the same. Now you are trying to improve on the Chinese version to reflect the intention in English. Is that right? Yes. Thank you. Please go on. Page 82. And subsection 4 has been repealed. So mentioning of subsection 4 and subsection 3 should be amended. And on page 83, again, it's a typo. And the first column mentioned subsection or section 35 brackets 1. It should refer to the supervisor instead of the management. So we are making this amendment. Page 84. Again, it's a typo. The section 31 brackets 2 brackets A should be corrected to 31 brackets 2 capital A. And on page 85, and 86, they refer to the same change. We think that in Chinese we should use 宣布 instead of 声明. And the English version remains unchanged. We are still referring to it as a declaration. And on page 87, and this is same as the subsidiary legislation 1B. For the subsidiary legislation H, it was it ceased to be enforced in 1994, but the subsidiary legislation was not repealed at that time. So we decided to tidy up this piece of subsidiary legislation. And on page 88, this is a textual amendment, and there are no changes to the meaning. The original meaning of poisons refer to those on the page on the left. And the same goes for page 89 and page 90. And on page 91, and this is the subsidiary legislation of CAP 369, and it has been amended, or CAP 369 subsidiary legislation AS. It was missed. So the latest name of the subsidiary legislation is introduced. There are no changes to page 92 and page 93, another technical amendment. And the original wording was the traffic sign number 168 or 138. And we would align it to become a sign in figure number 138. Is this a traffic sign? Is this graphic a traffic sign? Yes. Please continue. The same goes for page 94. And starting from page 95, we have changes to the marine ordinances. And we are changing a floating craft and a fixed or floating platform to floating craft and a fixed or floating platform. And for the word floating, it might not reflect the real state of the vessel. And it's reflected in 79, 80, 102, 103, 104, 105, 106, 107. Right till page 120, we are dealing with the same amendment in different pieces of marine legislation. Ms. Oden-Chow. For the ship, the Chinese amendment is 及固定式或浮式平台. What about the rubber boats or the so-called banana boats? Would they be considered a ship? Can anyone address this question? There are different interpretations of a ship under different pieces of marine legislation. I cannot say for sure whether the rubber boats are defined as a boat. It depends on the ordinance. And for each ordinance, there could be different interpretations to a single term. So I cannot give a general answer. All right, thank you very much. I tried to do some research, and I agree that they might not be defined as ships, but I just want to clarify this. I will do further research. I did not say whether rubber boats are or are not boats. for a fixed or floating platform, or 固定式或浮式平台. What's the English rendition? The English rendition is a fixed or floating platform, so no amendment to the English is needed. Yes. Any other questions, Mr. Chow? I will exercise my discretion. I hope that we can go through all the amendments to the Tax Statute Law Miscellaneous Provisions Bill 2017. We are 5 minutes to 10:30. I will extend the meeting by no more than 15 minutes to complete our scrutiny. Any objections? Well, even if you do, I have the discretion. All right, please go on. The subsequent amendments are relatively straightforward. On page 121, and we amend the Chinese version 加費額 to 加幅 in the Western Harbour Crossing Ordinance, and the same goes for page 122. And in Schedule 2, when you said rise, do you mean the rise in the amount of fee? It does not refer to the absolute value. You are correct. This does not refer to the fee of the tunnel fee. It only refers to the rise. On page 123, the Schedule 6 was about Section 24A and 26C, but they were both repealed, so Schedule 6 would be repealed. The same goes for page 124 and 125, and on page 126 it was a typo. On the specified sentence, it should refer to Section 3 brackets 1 brackets B instead of Section 3 brackets B. The same goes for page 127 and 128, and on 129, this is the about the Airport Authority bylaw, and it's related to the road traffic control road traffic control regulations, and it was amended in 2013. So there are consequential amendments to the Airport Authority bylaw. The legal advisor asked why this will go into effect on the 15th of December 2017, and this is because this corresponds to the commencement date of the road traffic control regulation. So we are trying to align the commencement dates. Did you consult the Airport Authority on this amendment? Yes. Mr. Chow, any questions? Please go on. Page 130. Again, this is a typo. And Section 64 is amended to Section 64A. Page 131. On under subsection 3, it should be Section 23 instead of Section 24. And page 132, it is a typo in the Chinese character used. And when you look at the English version, you can see that a phrase is omitted in the Chinese version. And the section will not apply to the persons in custody. And on 134 and 135, there's an error in the numbering. After brackets 3, it should be brackets 4. The final paragraph should be brackets 4 instead of brackets 3. And there are no amendments to the contents. This is only a change to the formatting. And on 136, the English text is amended. Perhaps we can look at this when we look at the English version later on. On 137 and 138, and this is to align with the mentioning of market or securities and futures market according to the other SNF ordinances. So we would just call a securities and futures market. And on 138 or 139, Section 3 is no longer present. We only have sections 5, 6, and 7. And on 140, companies ordinance kept 622 in the Chinese version. The auditors of a company has been omitted, but the English version is fine. And on 141, this is a change to the English version. Excuse me, on 141, this is the Hawker Urban Council Amendment Number 3 Bylaw 1994. It would be repealed, just like the scenarios I mentioned before. And on the final page, 142, and on section 64 ZZF, there's a typo, and it should be subsection 2 and 3 instead of subsection 2 or 3. Let's look at the English version on the copyright ordinance.
Hold it, John. If I may go back to page 140, just a minor point. I've just spotted that you would like to add Dick Hasosi. Let me read it out. I think there may be a minor problem. It talks about if the auditor preparing the auditor's report is a business, then the relevant person is the partner of the relevant company, because it is now the partner of the auditor of the relevant company. Thank you, Mr. Chow. I think our amendment is correct. Please try to read the other subsections. Say, for example, 2A of Section 408. We have a similar reference that is being appointed as the auditor of the relevant company. So we have checked with the English version, and we believe that we have indeed omitted Dick Hasosi in subparagraph B. Mr. Chow, anything else? No. All right. In this case, let's go back to Division 57. This is about copyright regulations. Copyright libraries regulations. Please go to page 96 of the English version. Yes, page 96. Well, for Cap 132, it is being referred to here, but then Cap 132 has already been amended. I mean, the title has been amended. You should now read Public Health and Municipal Services Ordinance. Therefore, for Cap 528B, we would like to update the title. Fine. Yes, have we finished everything? The legal advisor has reminded us that we haven't gone through the English version because certain amendments would relate to the English version only, other than the one we have just visited. Any amendments that relate to the English version only, that is, there is a need to update the English version but not the Chinese version. Yes, please, Mr. Chairman, if you wish, page 41. Page 41, and this is to amend Section 46 of the Bankruptcy Ordinance. Wrong spelling, first charge. Fine. If we have gone through the Chinese version, it will be fine. Yes, I'm asking my colleague to find out the relevant pages where we have an amendment to the English version only. Page 44, again, a spelling mistake requires. Understood. Page 50. Agreed to or effected by the instrument. The two commas in the English version have to be deleted because it would not be accurate to include the two commas. Page 51. It should read the proposed use, but then it has been wrongly given as user. Page 52. Paragraph B, carry out instead of carry on. Page 54. A boundary of the site instead of all the site. Page 55. In conformity to instead of in conformity with. Page 56. It should be a party instead of just party. Page 77. Section 225. There is one word which is superfluous, A, in front of the flag. Page 90. There is a grammatical mistake. We should have used the word is. So for the definition, we should use the word is instead of are. For page 91, it should be a personal identifier instead of personal identifiers. So it's a grammatical mistake. Page 93, that is similar. In front of personal data, we should insert the word any, and then instead of are, it should be is. Fine. Page 99. It's a technical amendment. Ordinarily resident in Hong Kong. It has now become a definition, so there's no need for us to be so clumsy in the English version. We don't need to refer to it being defined in section 2.1. There's no change in the meaning. Page 102. Again a typo. Premises and S has to be added. And that's it. We haven't got other amendments that are related to the English version only. So I think I've covered everything in part 9. Alright, our legal advisor, anything else? Mr. Holden Chow, anything? Well, we have very quickly gone through this amendment bill. This is the Statute Law Miscellaneous Provisions Bill 2017. Let's take a look as to when we are able to report to the House Committee and when we can go back to the LegCo meeting. Do we have a timetable? When are we going back to the House Committee? We haven't got a timetable. We will do it as soon as possible when we resume after the recess in October. So we'll report to the House Com and then we'll have the second reading debate resumed. Tentatively, it will be the 18th of October. As of now, we haven't got the schedule for House Committee meetings, but we will inform the relevant public officers in due course. So we hope to resume the second reading debate of the bill in October. Any other questions? If not, then thank you very much. I would like to thank members as well as the public officers. Thank you, Chair.